5 seconds to go. Start. It is informed that breakfast is served at about 7:30 in the morning, lunch will be served at about 11 am, and supper would be served at 4:30 pm. The inmates are free to consume the supper at any time they find it convenient, and they can eat sitting together. All the inmates, including Shri B.A. Umesh, informed that the quality of food is good and adequate. It was informed by the jail authorities that a minimum of 5 guards are posted in the barrack on a rotation basis. It was also informed that in one of the cells there is a TV fixed which may be seen by all the inmates together. It was also informed that prisoners are at liberty to purchase bakery items which are prepared by the inmates. If the instant matter is considered in light of these cases and the settled principles, the alleged period in the instant matter is of 2 years and 3 months, that is, starting from the receipt of the mercy petition on 3rd March 2011 by the central government till the disposal on 15th May 2013. It must be stated that soon after the receipt of the said mercy petition, the Ministry of Home Affairs, Government of India, forwarded the mercy petition to the Principal Secretary, Home Department, Karnataka, so that the Governor Karnataka could consider the mercy petition first. In the meantime, on 9th March 2011, in writ petition number 52 of 2011, preferred by the appellant, this court had granted stay of execution of death sentence. The matter was considered by the State Cabinet on 7th May 2012, which decided to approve the note prepared by the Home Department recommending rejection of the mercy petition. The matter was then placed before the Honorable Governor, who rejected the mercy petition on 6th June 2012. The copy of the order passed by the Honorable Governor and relevant documents were forwarded by the state government to the central government on 30th August 2012. On 18 September 2012, certain information was sought by the central government from the state government, which was furnished to the central government on 26 December 2012. The matter was thereafter taken up at the central government level. The Ministry of Home Affairs prepared an appropriate note for the Honorable President, who, after considering the entirety of the matter, rejected the mercy petition on 12th May 2013. Thus, the entire period beginning from 3rd March 2011 to 15th May 2013, spanning over a period of 2 years and 3 months, saw disposal of mercy petition at two different levels, one by the Honorable Governor and other by the Honorable President. All the while, there was an order of stay granted by this court on 19th March 2011, which was operating all through. First and foremost, the time taken by each of these authorities and the functionaries assisting them cannot be called or termed as inordinate delay, and secondly, it was not as if every passing day was adding to the agony of appellant. The order of stay of execution had put the matter in a different perspective. In the given facts and circumstances of the case, in our view, the first submission does not merit acceptance. We are conscious of the fact that in a recent decision in AG versus State through Superintendent of Police and another, a bench of 3 judges of this court commuted the sentence of death to life as the petition preferred under Article 161 of the Constitution had remained pending for 2.5 years with the Honorable Governor, despite the recommendations of the State Cabinet for remission of the sentence. In that case, no decision was taken by the Honorable Governor in spite of the recommendations of the State Cabinet, and as such, the benefit of commutation was extended. The facts which came up for consideration in said decision thus stand on a completely different footing as against the instant matter. We now move to the second submission pertaining to solitary confinement of the appellant. Reliance in this behalf has been placed on the decision of this court in Sunil Batra versus Delhi Administration and others, and also on the decision of Ajay Kumar Pal, in which segregation of the concerned petitioner from the day he was awarded death sentence till his mercy petition was disposed of was taken to be in violation of the law laid down by this court in Sunil Batra, and the death sentence was commuted to life on both counts, namely inordinate delay in considering the mercy petition and the solitary confinement that the concerned petitioner was subjected to. In the instant case, the letter written by Medical Officer Belgaum, Central Prison on 6 November 2011 did say that the appellant was kept in solitary confinement, and said letter has been heavily relied upon by the appellant in support of the second submission. According to the letter, the appellant was kept in solitary confinement since his admission to the prison in October 2006, and that apart from common illness such as diarrhea, fever, running nose, and backache, the appellant was found to be suffering from psychosis with depression. Pertinently, on 8th November 2011, a letter was sent by the Chief Superintendent Belagavi Central Prison to additional DGP and IG Prisons Karnataka to the following effect. Stop.